Right. So we're running a series of GDPR events. We've invited Alan Calder. He'll go through and then introduce himself in a minute. What I wanted to do was just do a little bit of a scene set with you from a TIG perspective. What we tend to do at these events, we don't go through reams of marketing about TIG, just a few bits just to position who we are as an organisation. And then if you're interested, there's a number of representatives from the organisation here. We can sit down, have a chat and tell you a little bit more about ourselves and how we might help you. Okay. So, I mean, from a position, I mean, how many of you, who here has not received at least 10 emails in the last month talking about GDPR? Okay, so pretty much everyone. Probably 5 from us, I would imagine. So I think there's no need to explain what it is, and I guess you're all aware of what GDPR is, and that's why you're here, to understand a little bit more about the intricacies and the detail that sits behind it, and what does it mean for your organisation. So I won't spend too much time.
George, so do you want to take questions as you go or at the end?
At any point really. I think the two things I would say, we've got a fire alarm at 10 o'clock, so there's a little interruption there. It's a test, and we do have a hard stop with the room at 11. So I guess what we'll try and do is try to get the questions that the whole group might benefit from out now, and then if we want to take any questions offline, we can go into the lounge after 11 and have a further conversation. If it's things that you think are relevant for everyone, please share. I'll skip through these slides because we're running a bit late. These are all about positioning. I'll move on to where TIG focuses some of its offerings. From a GDPR perspective, we're focusing purely on the technology, on the data side. One of the products that we're using to secure environments for our existing clients, and we've deployed this in insurance, legal, one accounting firm we're going through at the moment, and it's a product called EMS, Enterprise Mobility Suite. Has anyone heard of it? Okay. So it has a host of products within it that have been consolidated by Microsoft. So two-factor authentication, encryption from a email, and from a data perspective. So you can introduce classification, so things like keywords. If you type in a special project name, it will start to encrypt the email, start to encrypt the document, and that's all policy driven from AD. It has a product. So who's heard of Intune? Okay. So Intune is, you've all heard of System Center. So System Center, Intune is a product that's formed out of System Center that's effectively a way of managing devices, securing devices. So currently within your organisations, you're probably using a whole host of products to do what this one product can do. It's also got an advanced threat protection feature built into it. So what we're seeing is we're seeing clients actually do have data everywhere, and one of the things that we're trying to educate them around is once you've, and Alan will talk you through some of the challenges that you'll face in trying to make yourself compliant. But once you've classified your data and you start to understand where it is, how do you secure it? How do you encrypt it? How do you put protection around it that then travels with the data? So if someone does take a document outside the organisation, what level of security still applies to that document? And EMS allows you to layer that level of security on, because fundamentally it's AD driven, so you've got to be able to authenticate back with the environment to check for the security level before it allows you to do anything. We're going to share these slides with you. I'm just going to flip through just to keep focused. So, I mean, for us, there's obviously personal data and sensitive personal data, different classifications, and obviously there's different levels of data classification that you might have within the organisation. I think there's some interesting questions we can ask later on around where the differences are from a sort of legislative perspective from other regulations. So, you know, is there any accountancy firms here? Or law firms? First time ever. There's always a lawyer in the room. You know, it's from a FCA perspective, they've got to keep data for 7 years. How does that affect GDPR? So that's one of the questions we can ask a little bit later from his perspective. And this is just another slide around some of the product offerings. And this just sort of breaks down what you get within the product set. You get Intune, you get Azure AD, you get advanced threat protection. So it's quite a comprehensive product, and probably eliminates a number of other products that you have within the organisation. So just a couple of slides about TIG. So we're a managed service provider. So 24/7 provides support to organisations on a global basis. Cloud and connectivity, so we have our own cloud platform based across 2 data centres in London and in Birmingham. We provide connectivity solutions, backup. We use a product called a Segra. We also are a managed Azure partner, so we're what's called a Microsoft CSP. So clouds, so we actually can sell Office 365 and Azure directly to you wholesale. You transact with us rather than having to go through a Microsoft portal. And our transformation services, we call it transformation because we're typically, when we engage, we're helping transform, you know, into other disruptive technologies. You know, whether it's moving how you secure your data or moving workloads into Azure, and that's a part of transformation. So traditionally, it would have been called a professional services team. You know, the guys who come in and analyse your requirement and then do the work required to move you across to your new desired state. Some key facts about us. And these are some of the partners we work with. That was a bit quick. And some of the clients. Got some interesting transitions. Some trust me. Yeah,
Oh, that's still there.
Can't get on with it. So, just wanted to keep it brief as a brief introduction on TIG, because I want to spend as much time as we can listening to Alan and giving you the opportunity to ask questions. Any questions around the technology, I can come up and answer some of those after Alan's finished his presentation. We'll have general questions and answers. Okay, Alan, do you want to?
Right, so I'm Alan Calder. I'm the Chief Executive and founder of a company called IT Governance. It's a business I set up in about 2004, 2005, weirdly on the back of a book that I wrote about implementing information security in a business that I was leading. I don't know anything about information security, but I thought it might be a competitive advantage for the consultancy business that I was running. I couldn't find anybody to help me do it, but we were the first company certified to what's now known as ISO IEC 27001, the Global Information Security Standard. So I wrote a book that I thought might be useful to people like me doing that kind of a thing. And for reasons I'm still struggling to understand, it was taken on as the Open University postgraduate textbook. It's now in its 6th edition. And it led to me setting up IT Governance, which got the name IT Governance not just because it was the title of the book, but also because I had the view then, and still do, that if organisations are to deal with data protection and cybersecurity, it's going to be because boards get involved. Boards recognise their accountability for the security of data and drive it through the organisation. And so over the years, as IT Governance has grown, I've written a couple more books, but our publishing business is the heart of our organisation. We now have something like 150 or 160 titles. But what's grown out of that is a very much more substantial business operating across the whole of the cybersecurity and data protection field. So we deal with obviously information security, business continuity, incident response, penetration testing, PCI compliance. And we had a fairly small data protection business because as you're probably aware, in the United Kingdom for the last 15 or 20 years, mostly data protection compliance is something that people think of as something that perhaps other people might do, but you definitely don't. And you don't because really there's nothing in the way of serious fines to come, and the penalties for transgression are slim. And so data protection is mostly seen, I suspect, as something which is used by bureaucrats to avoid giving you information that you need to go about doing your normal daily life. Since GDPR was passed by the European Commission, data protection has become the fastest growing part of our business, now probably about 50% of our total activity. We're the market leader, excitingly or weirdly, in terms of accredited practitioner and foundation training. We've got a very substantial consultancy business, and so the work which we've done around data protection, which filters across all the rest of everything we do, has become really the starting point for many organizations to think seriously about how they tackle cybersecurity as well as data protection, because GDPR is not simply about ticking a few extra boxes in order to avoid a fine. It's something which drives a very substantial change in how organizations address the protection of personal data. We'll talk briefly about the background to GDPR, the concept of accountability, the principles of the regulation. We're going to spend most of the time talking about lawful, fair and transparent processing of personal data, which might seem like a very dull and dry subject, but it's right at the heart of what you've got to do to stay away from 20 million euros worth of fines. We'll touch on the issues of consent, what legitimate interests are, and we'll touch on how to maintain the confidentiality, integrity and availability of information. Just a couple of background things though. First of all, for those of you who don't know it, the key difference between directives and regulations. A directive is something the European Community produces. It's a directive to member state governments to produce laws of their own that meet a minimum set of requirements, whereas a regulation is a law as written. It goes into force in all member states by virtue of the treaties that found the European Union. So GDPR, as the name indicates, the General Data Protection Regulation, is a regulation. It goes into law as written. It doesn't depend on member states passing enabling legislation, although GDPR does have built into it a number of areas where member states can make their own decisions about what to do, what are called derogations in the law. And the United Kingdom, with a great amount of fanfare, is pretending that its current data protection law is a wholly new thing created by the British government. It isn't. It's the General Data Protection Regulation with a few of its derogations the British government has gone for, working its way through Parliament. There'll be a great deal of huffing and blowing around, let's have this clause and let's not have that clause, but the British government has no control over the regulation. All of that went into the negotiations, the 3 or 4 years worth of negotiations amongst member states to produce the regulation. So GDPR will survive Brexit, not only because Britain needs it to. Britain needs to have a data protection regime which is judged to be adequate, otherwise it will suddenly become very difficult for UK and European businesses to share personal data, but also because it's going to become part of the body of UK law. It comes into force on the 25th of May next year, and that means that that's the date from when you have to be in compliance with it. It's not the start of a transition period, it's the end of a transition period. The transition period started in May 2016, which was when the law finally worked its way through the complicated European democratic processes. So it applies from the 25th of May. It's binding in its entirety, directly applicable in all member states, and by that's the date from which you have to comply. What one means is that you need to have done everything necessary to be in compliance before you get to the 25th of May, not after. Now, the reality is that almost no organizations, so I'm exaggerating, no organizations will be compliant with GDPR by the 25th of May. And it's an impossibility to be compliant, not just because it's quite a big and complex piece of legislation, but because there are a number of terms in it which are not yet clearly defined. So there's a requirement that you, having carried out an appropriate risk assessment, put in place appropriate technical and administrative measures to protect personal data. I don't know if anybody knows what appropriate means or organizational measure means. No, and the law doesn't produce definitions for any of those. So one of the things to have clearly in your mind is that GDPR, like any other law, is going to be subject to interpretation in law courts. There will be lawyers keeping their children in school for 10 to 20 years to come, arguing over what specific terms and phrases inside the regulation actually means. There'll be a number of decisions which will work their way to the European Court of Justice. None of that really helps because you've still got to try and be compliant. You don't want to be the test case arguing over whether or not this is a legitimate interest or not. You want to try and keep out of all of those complex arguments. So you've got to do your best to find a way of complying with the regulation in spite of the fact that there are a number of areas which are not yet absolutely clear. GDPR applies to personal data, to the protection of personal data. It says that residents of the European Union, and it's not citizens, it's residents of the European Union, have a right to the protection of their personal data, to the protection of the processing of the data, and to freedom of movement of their data within the European Union. Protection of their data, protection of the processing of their data. That means if there's a ransomware attack, which means the data is not available for an operation to be carried out, you've got a personal data breach under GDPR. You've failed to protect data which you've collected for a specific purpose, i.e. to enable people to have operations. In scope of GDPR is personal data processed partly or wholly by automated means and personal data that is or is intended to be part of a structured filing system. These are important definitions because it clearly includes both digital and analog data, stuff on paper as well as digital information. It's all captured by the regulation. And it means that the only types of data that you can not include is unstructured, not the technical term of unstructured, but the legal form, which is a pile of business cards in the corner of the room that you can't even work out who's in there. That would be not a structured filing system. But as soon as you go and put them in a Rolodex, you've got a structured filing system. So you need to think about what the scope of GDPR is in those terms. It's intended to be part of a filing system, or intended to be, it's captured. And what drives the regulation is the idea that it's about protecting the rights of natural persons, not about protecting organizations, but protecting data subjects. And the requirement in the regulation is that organizations take heed of risks to the rights and freedoms of natural persons. Really key concept, the rights and freedoms of natural persons. Regulation applies to controllers and processes, both of which are clearly defined terms for the first time in the European Union, irrespective of where processing takes place. So if you're a controller in France, you're collecting data and you outsource the processing of it to somebody in India, well, it applies to all of that activity. Your subsidiary or your partner in India has to comply with GDPR, otherwise you can't contract with them. You have to contract with them in a way that ensures that you're meeting your obligation. It also applies to controllers not in the European Union, but providing services into the European Union. That doesn't mean, as has sometimes been suggested, that if an organization in America happens to have a website and someone from the European Union happens to go onto it and buy a book, that suddenly that organization has to comply with GDPR. It doesn't. The test is, are you providing services into the European Union or not? And GDPR has a number of identifiers that set out when that you wouldn't be captured by the requirement. You're captured by the requirement if you offer a delivery service in the European Union, if you take payments in euros or any other European Union currency. All of those would make it clear that you're offering a service into the European Union. At that point, you have to comply with GDPR. But more than that, you have to appoint a representative inside the EU to be the organisation to whom a data subject can bring a complaint and with whom a supervisory authority can liaise. If you don't do that stuff, well, hey, it's a business decision. You don't have to. Laws are just business decisions. Many organisations decide to break laws day in and day out. With GDPR, if you decide to break the law and you're caught, the fines go up to 20 million euros for the most significant range of transgressions, and those are to do with breaches of human rights, breaches of the 6 data processing principles, and breaches of the requirements around transport and data processing. There's a whole set of other items clearly identified where the fines go up to a maximum of 2% of global turnover or 10 million euros. In every instance, the supervisory authority is required to take account of the extent of negligence in the organisation. So if you've done the best you possibly can and you still had a breach, you wouldn't expect being hit with a massive fine. Fines have to be both effective and dissuasive, but also proportionate. Proportionate in law means that if you're only turning over £2 million, you can't be fined 20 million euros. It's completely disproportionate to the size of the organisation that is offended. So whatever GDPR says, remember it's embedded in a framework of law and tradition across the whole of the European Union, and it will be interpreted and applied as such. But 20 million euros, 4% for larger organisations is a significant challenge. For large organisations with lots of subsidiaries, while technically the legal situation would be that a breach in the subsidiary would lead to the subsidiary being fined, there is a concern that if the parent company exercises control over the subsidiary and hasn't made sure that it's compliant, action could be taken against the parent company. That's simply a concern. Remember, the law hasn't come into effect yet. It doesn't apply until the 25th of May, and you can't be sure about any of these scare stories until you begin to see court cases. Of course, you don't want it to be the end of a court case, so you have to make decisions in that context. The two ways that you get to be in trouble, and while supervisory authorities have the power to carry out investigations, to come and do compliance checks, we suspect that it'll be some years before they've got the resources available to enable them to actually do that. The ICO in the UK currently is something officially like 50 people short of where they need to be. They're desperately asking the private sector to give back some of the folk who've left in the last 6 months for the higher salaries that they get in the private sector. So, you know, the ICO's got this big challenge of enforcing the regulation, but just may not have enough staff to cope.
ICO?
Information Commissioner. So the supervisory authority for data protection is the same Information Commissioner who's been in charge of data protection for the last 20 years. So the two ways that you get into trouble, and as I said, the supervisory authority can impose administrative fines taking account of the nature, gravity, duration of the infringement. It's difficult to imagine how a Yahoo would survive an infringement which took place over a number of years where they didn't manage to pick it up. You would expect the Information Commissioner basically to be saying, well, you know, that's kind of the maximum, that's 20 million euros, and they'd be thinking about, well, they wouldn't, they'd go for 4% of global turnover, wouldn't they? So you'd say, by my Yahoo. The degree of responsibility of the controller or processor taking into account the technical and organizational measures implemented. So the two ways that you get into trouble, the first is data subjects. Data subjects have, under GDPR, these references are to articles in the regulation. You can download it from the European Commission website. It's written in all the languages of the European Union. It's not written in complicated legal language. It's very clear, so you can read it. You don't have to believe what anybody tells you. Article 82 says that any person who has suffered material or non-material damage has the right to receive compensation from the controller or processor. Now that looks innocuous until you recognize that non-material damage includes a data subject, an ex-employee perhaps, who didn't really like you when they left you, discovering that you've kept their data on file for the last 15 years. And they get so upset and concerned by it that they can't eat properly, their sex life is destroyed, they get signed off work, and that means they bring a case against you for financial compensation for the non-financial damage they suffered. And there's no ceiling on the award that courts can make for those types of claims. I don't know about you, but I suspect there are one or two people in the world who might be of the sort who will pursue those opportunities. I suspect that there may be one or two law firms who might recognize the opportunity to help people get their rights looked after. So the first place you get into trouble is because somebody brings an action. And they're entitled to bring actions for simple things like, I asked you for my data and you didn't give it to me. Certainly not within the month that you now have to do it, or you thought you'd charge me a tenner because you could do that under the previous regime, but you can't do that now. You didn't give me all the data. You failed to facilitate the exercise of my rights. So when you give them the data that they're entitled to have and they go through it and they discover that you've been processing their data for longer than the original purpose for which it was collected, you breach their rights. So data subject access request you can think of as the starting point for a potential action being brought by a data subject.
I'm not sure if I should take this question later or here, but I'm really struggling to get my head around if you past employees and you have surely have a duty of care to keep that data for various reasons, not that there may be litigation.
So we're going to come to the,
okay.
absolutely we are, but it's, if
Someone
you don't have a lawful reason for keeping the data,
Okay.
then they can bring an action. If you have a lawful basis, you're in the clear. And so that's why we're going to talk quite a lot about lawful basis, because it's a pretty fundamental bit of keeping out of trouble. And most organisations don't actually have a lawful basis for most of the things they do right now.
Just because they think they probably have to, but actually they don't.
We'll talk about it.
Right.
So the controller is liable for damage. If the fact that you've outsourced the processing to somebody else and the processor is in breach doesn't get you off the hook, the action comes against you, the controller. And the definitions of controller and processor are organisation level, not individuals, as the old Data Protection Act might have said. So if you happen to contract with a wages payroll bureau in Malaysia and their security is terrible and they have a breach, the Information Commissioner will come to you and say, you're the controller, and you say, it's not my fault, they're useless, fine them. And the controllers, the Information Commissioner will say, I'm not sure you're paying attention, you're the controller. You chose them, therefore it's your fine. It's up to you if you want to try and recover the fine from your processor, and the fact they've gone out of business is also your problem, because you're the controller. You're accountable for what happens to personal data of those people whose data you gather. So being a controller is an onerous responsibility. You don't want to go, it doesn't really matter whether I'm a controller or a processor. Where personal data is concerned, you have to be one or the other. You could be a joint controller, but it's the same. You're a controller. And you do not want to think that you're a processor and not have a controller who's given you a contract. Because it's illegal to process data without a contract from a controller or as a controller. Those are your only two options. The second way you get into trouble is a data breach. Under the Data Protection Act, there's no legal obligation to report breaches to the Information Commissioner, and so nobody does, apart from the public sector who've been told by the government they have to. Private sector, the only time people report breaches to the Information Commissioner is where you think you might get found out anyway, and you try and reduce the size of the potential fine that might come under the current regime by owning up to it. You now have to report, and as a controller you've got 72 hours from the point at which you first become aware of it, or sooner, to report the breach. And that includes reporting breaches that have taken place in the processors with whom you've contracted. So it's no good saying, the processor didn't tell me about the breach for 6 months. Because they had to tell you by law within 72 hours, and you had to tell the Information Commissioner or the Supervisory Authority, if you're not in the UK, within 72 hours. Nobody knows whether those are concurrent or in sequence, those two sets of 72 hours yet. We suspect that you should assume that they are concurrent, but it could be in sequence. Without undue delay and not later than 72 hours, there's some circumstances under which you don't have to report a data breach, and the definition of data breach is massive, just like the definition of personal data is massive. Personal data is anything that enables a person to be identified. Obviously, name, address, passport number, driving license number, but online identifiers, IP addresses, they all enable people to be identified. They're all explicitly captured by the definition of personal data. If you're processing the data of individuals as an ISP, you're collecting IP addresses. That's personal data. You're captured by GDPR in just the same way as if you're collecting names and addresses of people. You don't have to report a breach where it's clear that there is no risk to the rights and freedoms of data subjects. You as a controller make that decision. No risk means, as far as we can see, under current guidance means, for instance, the data is encrypted, because there's no risk. Or it means that there's been so little data compromised, or it's been a minor loss of data which was recovered 15 or 20 minutes later. Remember, an accidental deletion of a file is a data breach. Anything, accidental or deliberate, deletion of data, compromise of data, any one of those fall within the very broad definition of a personal data breach. So mostly we're used to thinking of data breaches as things that happen when an attacker hacks us. GDPR says, that's just one form of it. Data breaches accidental, people with big fingers, people deleting stuff by mistake, they're all breaches. They're all compromising the confidentiality, integrity, or availability of the personal data. You only don't have to report it as a controller if there is no risk to the rights and freedoms of natural persons. So you need a process that enables you to, one, identify incidents, and two, make decisions about whether you need to report them or not. Most organizations don't even have a process for identifying incidents. I promise you, you don't want to have a breach which typically takes place on a Friday on account of that's when the IT people head off for their afternoon beers. They've had a tough week up until then. And breaches happen therefore on Fridays because attackers know they've probably got until Monday before anybody sees there's been a breach. Your 72 hours runs from the point at which the breach occurs, not from the point at which you turn up for work. You should have been aware of a breach on a Friday. Your systems should have enabled you to capture it. So you don't want to be working out on Friday evening or Saturday morning while you're in the pub. How do we determine what we've got to report? You want to have a data breach reporting process that's tried and tested well in advance of having to use it, and then you hope you never ever have to use it. So imagine what happens if you have a breach. You report it to the Information Commissioner. You say, we had this breach, we think a whole bunch of data has been stolen. What do you think the Information Commissioner is likely to do?
Fine you.
Before they fine you, what are they going to do?
Ask for an explanation.
Carry out an investigation. Now, the investigation is going to reveal not just that you had a breach because something went wrong, it's going to reveal that there's a whole bunch of stuff you're not doing right. A whole lot of processes you don't have in place, the board's not aware of what's going on, you don't have an accountable director, for instance, you don't have a data protection policy, and the fine will be based on the posture of the organization, not on the minor transgression. All the supervisory authorities and GDPR is crystal clear that fines will be based on absence of proper accountability. So you've got to think about GDPR not as a set of things, boxes to tick, but as a way in which the organization has to start behaving. You have to start thinking of the protection of personal data as being fundamental to the organization. And it's these 6 data processing principles, and sitting across it, what's in effect the 7th principle, which is accountability, that is at the heart of what you've got to do. And to an extent, if you can demonstrate that you're doing what each of these 6 principles say you should be doing, you will be very substantially where you need to be in terms of GDPR compliance. You ignore the other 100 articles. If you're doing this stuff, which is all set out in Article 5, these 6 data processing principles, you will be substantially where you need to be. The accountability principle in Article 5, GDPR says that the organization needs to be able to demonstrate accountability in respect of those 6 principles. Every definition of accountability that you look for will include words like, in organizational terms, governance, where the buck stops, board, senior management, roles and responsibilities. Those are all parts of a standard accountability framework. If top management doesn't have GDPR compliance on its board agenda right now and you have a breach, you're going to be struggling to demonstrate any grasp of the idea of accountability. There's no good just having GDPR on the board agenda because that's worrying about impacts on the organization. What GDPR says you have to worry about is impacts on the rights and freedoms of data subjects. So you don't want to be saying, if we have a breach, it's going to affect the organization's reputation from a GDPR perspective. From a risk management point of view, of course, that's what you want to do. But from a GDPR perspective, you want to be saying, if we have a breach, it's going to affect the rights and freedoms of these individuals. If we have a breach of our systems, if you're a national health hospital and you're running an operating system which is, oh, let's pretend it's out of service, out of support, and Microsoft says, don't worry about that, we'll make it available, make support available for you on an ongoing basis at a much lower level than normal, and you go, we don't really want to spend money on that, we'd rather spend it on patient operations. Actually, what GDPR says is, you should think about this a little bit more, because if you happen to have a ransomware attack, which closes down your systems on account of you haven't got up-to-date operating system, as a result of which you have to cancel operations, you won't be able to stand up and say the good news is we didn't have a data breach because no data was stolen, because you'll just be wrong. You had a data breach because you weren't able to use the data for the purposes for which it was collected, i.e. to carry out operations. And the fact that you weren't means there'll be a whole bunch of people who, when they get off their gurneys, are likely to bring actions against you for your failure to protect their data. So you've got two problems in that instance. You've got data subjects bringing actions against you, and you have to report a data breach, with the result the Information Commissioner is investigating you on two different bases, either one of which could lead to a fairly substantial fine. We're going to talk mostly this morning about lawfully, fairly, and in a transparent manner. But the key thing I want to say is it's this principle here, the second principle, that if you get this right, will make most of the others quite straightforward. What the second principle says is you must collect data for specified, explicit, and legitimate purposes. This is a law, so it's worth knowing what each of those words actually means and then doing it. Specified means what exactly are we going to use the personal data for? I don't know if you've ever found yourself in a situation where somebody says, if you tick this box, we'll send you some information and use the data for some purposes, or words to that effect. Yes, does that happen? So that wouldn't meet the test for specified. It's not specified, it's just vague. Give us data, we'll do something with it. Explicit. Explicit means, actually I need to know exactly what it is you're going to do, how long you're going to keep it for, who else is going to see it. And the purposes need to be legitimate. Legitimate, again, is defined in law. We'll look at what legitimate is shortly. But legitimate doesn't include, I signed up to get some information about fridges, and the next thing I know, I'm getting mail shots from all over the place about taking holidays in Azerbaijan. How did my data get from there to there? The sharing of the data was not legitimate. So, if you get really good at, from every bit of data that you're collecting, being clear about what the specified, explicit, and legitimate purpose is, complying with the first principle is fairly easy. So let's talk about the first principle, which says lawfully, fairly, and in a transparent manner. The principle is known in short terms as the lawfulness, fairness, and transparency principle. And the requirement is that you have to meet one of the conditions in Article 6 we'll look for, and in the case of what are called special categories of data, what the Data Protection Act used to call sensitive data, it's now called special categories of data. The term sensitive data is gone. It's prohibited to process that data unless you've also met one of the conditions set out in Article 9. So it's worthwhile beginning to get into your head the mantra around lawfulness of have to meet an Article 6 condition. If we're processing special categories of data, we have to have also an Article 9 exception. So, exciting, isn't it? The point about lawful processing is that if you don't have a lawful basis of processing, you can't process the data because it's illegal. That's what lawful means. So think about getting to the 25th of May next year and you don't know what the lawful basis is for processing all the personal data you've got. On that day, you're breaking the law in respect of all of that data. Because you have to comply on that day forward, not with data that you gather after that day. The data you're processing on that day has to be in compliance with GDPR. That means all of the data about your employees that you're processing, you have to have a lawful basis for doing that. All of the customer data. GDPR doesn't distinguish between consumer information and business information. So a business email address is personal data. Alan Calder at itgovernance.com is personal data. So all of the contact details for your customers and your suppliers is personal data. Suddenly, without a lawful basis, you can't process it. Technically, from a legal point of view, if you haven't sorted your problem out by then, you stop. Because, by definition, you're breaking the law. You don't have a lawful basis for processing the data. Exciting, isn't it? So, how do you get it to be lawful? The first is the data subject gives consent. Looks as though it's easy, doesn't it? Yeah, just get the data subject to give consent. But what do you give consent to? We had a conversation with one of our customers who said, you need to get all of your members of staff who are going to be working on this project to give their consent to us processing their information for whatever purposes we think fit. We said, no. Not only can we not force people to give consent on account of the definition of consent excludes the use of force, but using it for whatever purposes you think fit is kind of not specific, really. Is it? We spent a month arguing with their lawyers over that. It was really interesting. So, data subject has to give consent for one or more specific purposes. The processing is necessary to meet contractual obligations entered into by the data subject. That's the second possibility. Processing is necessary to comply with the legal obligations of the controller is the third option. The fourth is that it's necessary to protect the vital interests of the data subject. The fifth is it's necessary for tasks in the public interest. And the sixth is it's necessary for purposes of the legitimate interest pursued by the controller. So the good news is that it's probable that you're already applying one or other of those lawful bases for processing to most of the data you're currently processing. The problem is that you haven't linked a clear lawful basis to each element of data and what you're doing with it. And so one of the things you've got to do between now and May next year is get for every item of data you're processing, one of these lawful bases attached to it, with the evidence to indicate that it's correct. Now, in the UK, we typically just go, let's get consent because that's easy. From a GDPR point of view, you want to treat consent as being, it's the only option I have left. Because consent brings with it, by law, a number of challenges. The first is that consent has to be freely given. Free means there can be no force between the two parties. Consent, when given, has to be able to be withdrawn as easily. That means that when consent is withdrawn, you stop processing. So if you're relying on consent to be able to send people marketing literature, they can withdraw consent and you have to stop. Seems fair, doesn't it? But you have to stop immediately. You can't stop in a couple of weeks' time when you feel like it. It has to be exercised with the same speed that you exercised what you did when they gave consent.
How implicit or explicit consent?
We'll come to consent, because explicit is the right answer. The consent gives automatically the data subject the right to erasure. They have the right to have deleted data which you've gathered on the basis of their consent. It's automatically linked. They automatically have the right, there are other conditions attached, they automatically have the right to data portability if they've consented to the processing of their data. So if you're relying on consent, you automatically give data subjects additional rights. Now think about relying on consent as the basis for processing the data of your employees. And I'm prepared to bet that every single one of your employment contracts has in it words to the effect of, and you consent to our processing your data for whatever purposes are necessary for you being employed by us. That'll be an invalid consent because the employer-employee relationship is in law not an equal one. So because it's invalid, you can't depend on it. Even if you could, and the data subject withdraws consent, what do you do when the data subject says, I withdraw my consent to you having my bank details? You're going to say, well, then we won't pay you? You can't, because the contract still requires you to pay their salary. They're entitled to withdraw consent to the use of their data, but that doesn't change the contract. You have a contractual obligation to pay their salary. You don't want to rely on consent in employee contracts for both of those reasons. Processing necessary for contractual obligations entered into by the data subject would be a practical lawful basis. So you would want to say, in respect of certain elements of data you've gathered from employees, we're processing this data in order for you and us to meet the contractual obligations you've entered into with us. You've entered into a contractual obligation to be employed by us and do certain things, and in return we're going to pay you some money. In order to meet that, we need to process your bank details. So from this, I think you might begin to recognize that you have to get a lawful basis for processing for each element of data, not for a whole set of data. So if you're looking at employees' details, you're looking at their name, home address, you're looking at bank details, you're looking at perhaps career history. Each of those is a different set of data, and you might need a different lawful basis for processing each of those. Health information is another category of data. It falls into the special categories of data. So for health information, you need one of these lawful basis for processing, and you need one of the exceptions we'll look at in Article 9. So for most employees, your starting point is going to be contractual obligations. For a lot of the data, your lawful basis is going to be so that you can comply with your legal obligations. And you have legal obligations in terms of things like national insurance, PAYE records, corporate records, VAT records, and all of those kind of things. And those laws set retention periods. They say that you have to collect this type of data and you have to hold it for that period of time. So in your notice to employees, you will say, your payroll information or your bank details we're going to process for this reason. We're going to keep the data about what we've paid you for as long as HMRC tells us we have to, because we have legal obligations that we have to meet. So one of the questions I think you're asking is, what happens if you have a legal obligation to keep data? What do? Well, you keep it. You have a legal obligation. And GDPR says very clearly that you keep data only for as long as the original purpose, unless there is an overriding statute.
About to be tested.
Unless there is an overriding...
Attention, please. Attention, please. Fire has been reported in the building. Please leave the building immediately by the nearest exit. The fire alarm test is now completed.
That really worked. So you're going to have a lawful basis which identifies for each of the different types of data you're processing what the lawful basis is and the time period during which you're going to keep the data. It might be necessary to protect the vital interests of the data subject. That's, vital is a specific word, so you can think of that as applying when somebody's on the gurney. Do you need to get them to consent to processing data about their blood types? No. If you don't get the right blood into them, they're going to die. You can collect the data from wherever you need to. The lawful basis is in order to protect the vital interests of the data subject. Only if you're a public authority or carrying out a public authority task will option 5 apply, and the legitimate interest, which we'll come to, could include a number of areas that you might choose. So if somebody has signed up to your website and said, please send me X amount of information, you don't have to also ask for their consent to do that. They've asked you to send it to them. So you could say we're going to process this information because we have a legitimate interest in sending you what you've asked us to send you. That's a perfectly legal interpretation of what this says. And the practical reason, you might be sitting there thinking, but what the hell difference does this really make? The difference it makes is in law. If the lawful basis of processing is legitimate interests, then the data subject doesn't have the right to withdraw consent. If they don't have the right to withdraw consent, you're not obliged instantly to stop whatever you're doing. What they do have is the right to object to you processing. And you have to handle the objection, but it's a different method of handling and you've got different time frames related to it. And the decision making about whether you agree with them or not is not as obvious as it is if you're relying on consent. So these are all areas where you're probably going to think, maybe we should talk to our lawyers. And probably you should, because getting this kind of stuff right in detail is going to make quite a big difference to the smoothness with which your business operates. It's very easy to overreact, in our view, to GDPR and create barriers to being able to talk with customers, to put in place a whole set of steps and tests that make it very difficult for them to sign up with you, to buy stuff from you, to do business with you. GDPR is not trying to make it difficult for people to do business. It's simply trying to make sure that data subjects' rights are protected. And so as an organization, if you apply yourself to thinking about what does this actually mean, how do we comply with the law while not screwing up our business, you can usually find a practical way of doing that.
Alan, your example there of if a customer or somebody writes in and asks you to send them information about fridges, for example, using your example, does that give you the right to just send that on one occasion, or if there's an update to those fridges in 6 months' time, can you then send them that information again?
So the test, and we'll come on just now to legitimate interest, the simple test is what would the data subject expect?
Right.
And if the data subject might reasonably expect that if there's an update you'd send them information, then you'd send them information. If you think, actually, I think they could really be interested in buying wood-burning pizza ovens from us.
Yeah, that's not going to work.
Correct, because the data subject said, but why me? And so, so legitimate in law requires you to think carefully about what's necessary. So let's look at consent. And when you're looking at lawful basis of processing, you really want for each element of data only one lawful basis. Don't have 2 or 3 and say, look, I got belt and braces, one of these will work, because one of them might also not work. And you'll be skewered on the one that doesn't work. So choose just one and make sure that you're able to make it stick. Consent must be freely given, specific, informed, and unambiguous indication of the data subject's wishes, in which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data. It's the definition of consent. So what is a box which says, if you don't want to receive data from us, untick this box? How does that meet this test? It doesn't, does it? So consent by default becomes illegal. Every single instance on every single website, every single email which says, if you don't want to get more of this, do X, is illegal. Because that's not a clear affirmative, yes, I want to get it. You're basically relying on people giving up.
It's opting out, not opting in. It's opting out, not opting in.
Yeah, you have to opt in. And there are some parts of the world, the Direct Marketing Association, for instance, which likes to rely at the moment, because they're quite short-sighted, frankly, on the existing Privacy and Electronic Communications regulation, which is about to be replaced by the new e-privacy regulation. The existing PECR allows for what's called a soft opt-in for business customers. And the Direct Marketing Association is hoping somehow that that's going to survive. It won't.
I'm guessing you're going to come to this, but where does this fit with existing data? So imagine I've got a database of 2,000 people who I by hook or by crook have got them into my MailShot database. Do I have to go through them all now? Did they specifically, didn't they do that? And do I need to start with a clean slate? Or is it by data that I gather after the 25th?
No, on the 25th, all the data you've got needs to be processed lawfully.
So all the existing data needs to match all this criteria?
Correct. Now, that doesn't mean you have to go back in time and work out how you got the data. In practical terms, that's almost impossible.
Yeah.
So what you're going to do is you're going to look at the data, you're going to say, now, what is a sensible, lawful basis? We're suggesting to our customers that the practical approach with email databases is to email the customers. Don't email the ones who said, don't email us. No, this is important.
It's a grey area.
It's not a grey area. If they said, don't email us, don't email them.
You should have their details on there.
But you've still got the details.
Should you? That's a question that GDPR is going to have to answer. If you've got a don't email us list, you're processing their data. By definition, you're processing their data because you've got it. And the definition of processing includes, I'm just holding it. I have a look at it every now and then. I compare my incoming email new list I've just bought with my don't email list. That's processing that list. If the data subject says, don't process my data, you're breaking the law.
If it's just static data and you're just holding it,
you're processing it because you've got it.
And you can search it.
Exactly. You can even just have a look at it manually. You're processing it.
And it could be breached.
Correct. So you've got to do one of two things. You've got to hope that there's a legal case which says, no, it's okay to hold that data because that won't count as processing because you're holding it in order not to send them emails they don't want.
Or for legal, for historic reasons.
Or for some other statutory overriding reason. Yeah, that could work. Or you've got to delete it. And then when somebody says, well, I told you not to email me, you go, did you? How would I know? I deleted anything I'm told to delete. That would work. Definitely told you to stop. Well, then we would have stopped. That's our process. We automatically delete everything where somebody says delete. We've probably got your data on a new list and we can tell you where it came from.
Now that's an interesting point because previous slides back, you mentioned deleting of data as an illegal activity. And I was like, I still couldn't get my head around that.
Right.
So is deleting data not valid either?
No. If you're deleting data while you're processing it for a specific purpose to which you collected it, that would be a data breach.
Right.
At the end of the period,
supposed to have the data,
when you're supposed to have it and you delete it, that's a breach.
So there's going to be
When you've ceased supposed to have it,
right.
then you should delete it.
Right. And
So
then
you
could
only
find,
keep
you could
it.
find out months and years later that, oh, actually I did need that data after all.
Right, so you need to work out quite carefully what the logical basis is for keeping data.
People are just going to fold up, I reckon. It's going to find it too hard basket and just wrap
Well,
up the business.
our view is there's probably a 5 to 8 year period during which people work out what compliance really means. And there are going to be a lot of court cases, going to be a lot of fines, and people go, is that really what that means? Okay, we'll better go away and get on with compliance. That's how it's going to... We still have people phoning us right now say, we'd like some help to get compliant with the Data Protection Act. We say, You know the Data Protection Act's about to be replaced with a new regulation which comes in May. They say, we've heard that, but we thought we'd just go for the Data Protection Act first. We go, yeah, all right. So, you know, there's going to be people just getting their head around GDPR in 15 years' time. What's this GDPR thing?
It's still Windows 98.
Yeah, exactly. So,
So when we email customers asking them if they consent, we've got to wait for a response, and if they don't consent, we've got to
It's
stop
true.
processing their data.
so you want to think hard about not using consent as a lawful basis. Right? Consent has to be positive and affirmative.
The last option.
Yeah, exactly right, last option. So if you want to email people, you really want to be looking at, do I have a legitimate basis for doing this, a legitimate interest in doing that? Because then you can email them and say, I'm emailing you because I think I've got a legitimate interest in doing this. If you don't agree with me, this is how you can object. And then you have to act on their objection, but actually you're shifting the onus to them and away from you.
Do you have to give a time period for that?
No, they can object any time.
No, but can we give them a time where they have to answer within a certain
No, because you've got your legitimate interest, you can do it.
But that's not positive consent, is it? They
No,
have to
because
object.
you're not relying on consent.
Oh, okay.
That's why I say understanding the words and the options is so important.
Yeah.
Consent is a very specific, affirmative, yes, I want it, triggers the right to withdraw consent, triggers the right to be forgotten, triggers the right to data portability. I've got a legitimate interest in doing this is a different lawful basis. Doesn't require consent. You just have to be clear you actually have a legitimate interest, and you have to tell them how they can object. But you shift the responsibility to the data subject to object. And if they object, you have to consider the objection and do all of that stuff properly, but it's a different relationship. And so mostly we're saying to customers, particularly with databases, with customers, look at how you can use legitimate interest. Otherwise, you're going to lose most of your emailing list. Of course, there's a counter-argument that says, why email people who don't want to be emailed? But that's
So just like reason being that you can keep the data so it's referenced so that you know you cannot email them.
that's definitely an arguable case. But you would need to tell the data subject that that's what you're doing.
Okay.
Because the requirement for transparency says they need to know.
Okay, so even though they don't want to be emailed, you need to email them.
Yeah, you can. That's a perfectly reasonable thing to do because the law requires you to. It says that you have to tell somebody what you're doing with their data and tell them what their rights are. So if they write to you and say, don't process my data anymore, you can perfectly reasonably have a process which involves you responding to them saying, got your message, there's two options. One is we delete you completely. The other is that we hold you in our database of people who do not want to be contacted, in which case this is how we'll use the data. We think we've got a legitimate interest in doing the second. If you disagree with us, this is how you can object. You could do that, or you could say, choose one or the other. Both of those are strategies that you could put in place. But if you're planning to keep the data, you need to have worked out how you're going to deal with that. Because sooner or later, you're going to be breached, and it's going to be discovered that you're holding 1 million email records of people who said, don't process my data anymore, and who assumed, therefore, that you wouldn't, who didn't know that you were keeping a record, a database in order for you to make sure you didn't mail them other stuff. But now they've been breached, now they're going to bring an action against you for identity theft and all of the stuff that follows from it. And you're going to be saying, but, we didn't know, we weren't doing anything bad. And the Information Commission is going to say, but which bit of this law here didn't make sense to you? And you're going to go, but we didn't even read it. And then it goes, so why do you think that's not negligent? And you go, and then you go, well, that's the top end of the fines, negligence. And you go,
Right.
So anyone that's suppressed or in like an emailing software, or somebody that's unsubscribed, you still need to get in contact with them somehow for them to consent.
There is a specific, which we'll come to shortly, a specific obligation that you tell data subjects how you're processing their data and you tell them what their rights are. And if there is a change in what you're doing, the obligation extends to telling them what the change is. So if you've been processing their data in an email marketing database and your lawful basis is legitimate interests, and you've been transparent and you've told them how they can object and they haven't, and then after a while they do object and they say, please stop processing my data, now you at that point say, now I want to put you in my suppression list. You've changed the basis on which, or the purpose for which you're processing the data. You're no longer processing in order to send them information about fridges. You're processing in order not to send them information about fridges. So you need to say to them, here's a change in the basis of processing, and this is the grounds, the lawful basis on which we're doing it, and this is what you can do. You can object, or we'll make it a consent, or whatever it is. But you need to tell them what you're doing. And the fact that you've done that means that when there's a breach and the information commissioner comes hustling in to see how big the fine can be, you just go, here's my communication process. And they go, tick, done, go away now.
Hopefully they're opening a can of worms in case you're going to come to it. That's all well and good for marketing and newsletters and mail shots and all that sort of stuff, but the overarching statutory requirements for current and ex-employees and current customers and past customers, because if you're under a VAT audit or a tax audit and you have to go back a certain amount of time, you're going to have to maintain client invoices. And the same with, I guess, PAYE, national insurance investigations, you'd have to maintain past, current and past employee information. Purely and simply, that arguably satisfies the statute requirement. I don't have to have any other.
No, but you have to identify to the data subject what the lawful basis of that processing is.
Do I have to explicitly tell them, you were a past employee, I'm keeping your data for 7 years?
Not my data, I'm keeping this specific data for 7 years for this specific purpose.
I'm keeping your first name, last name, national insurance number, bank address. I have to list each field.
And why would you keep their bank details for the purposes of the VAT or HMRC audit? You don't need bank details.
Because I don't know.
I'm just saying as an example.
I'm guessing because HMRC didn't want to go after the employee for not paying enough tax, and want to go and request the bank information from the bank, and then the bank.
By all means, then you need to tell the data subject keeping the details in case HMRC wants to pursue them. Right. Okay, so that's the second principle. The second principle is specified, explicit.
Do I now have to understand and ad infinitum, verbatim, all of HMRC and VATs?
No, you go to your lawyers, you go to your professional advisor and say, give me a retention schedule that makes sense, that I can apply in my circumstances, because all companies have employees, all companies have to deal with what's the retention period for HMRC audits, for VAT audits, all of that stuff. And that is a set of basic rules. So you just want to go and get a set of retention guidelines and you want to apply them.
And then I'd have to contact all those people and say, this is what I'm doing.
So the principle is it has to be transparent.
Yeah.
They have to know. So you have to tell them. But
do they know that in advance, or do I now posthumously have to do it before May the 28th?
If they're dead, it doesn't matter.
No, sorry.
Dead people.
Well, you say
dead people have no rights.
Heirs of the estates, though. There could be heirs to the estate, though.
The heirs have rights, but dead people have none. No, seriously, it's a specific point in GDPR. Dead people have no rights.
They're being told our lives.
Former employees.
Former employees,
Yeah,
yes, you're processing their
You have
data.
to contact them.
Yeah, you're processing their data.
Assuming, I mean, you have to make your best effort to contact. What if they've moved address? What if they've left? What if they've changed email address and moved house?
Well, you kind of got a problem, because if you've got a reason for processing their data, you need to keep the data up to date.
Yeah.
Oh,
That's a current requirement of the Data Protection Act, that you keep data up to date for the purposes
So
of
some
which you
employee that
collect
lived
it.
7 years ago has moved house 5 times. On
Correct.
Thursday.
If you needed to keep their data, if there was a purpose for keeping their data, you needed to keep it up to date.
And for new employees, is it sufficient to put that in the contract?
So the smart thing to do with new employees is not to put it in the contract, is to
Just
say that
consent.
we're going to be processing a number of different elements of data for different lawful basis, and we'll retain it for different periods. See the staff handbook.
Yeah.
Because there will be changes in the law. Yeah, put that for, just like health and safety.
Staff handbooks, they're not in the contract.
Put the detail in the staff
In the staff handbook,
but the
correct.
contract refers to.
Correct, because there will be changes. You know, there are changes in retention requirements and changes, and you don't want to go out and issue new contracts every time there is a change in the definition of a lawful right.
I mean, that's just employees, and they're ex-customers.
Yeah. So do you have a lawful basis for processing the data of ex-customers? Why do you keep their data?
Invoices. So
Okay.
if I get investigated, I need their invoice information.
Right, so you have a lawful basis there. It's a statutory
But do I need
obligation
to
to keep
contact
company
all my
records.
clients to say, I'm keeping these invoices because of X?
That's what GDPR says.
Technically.
There is a
That's
business
isn't it?
decision. There's a business decision to make, which is it worth it?
And will they care?
And will they care? And you know, there's nothing in GDPR which tells businesses how they should perform. It just says this is the law. There will be some businesses, and of course some lawyers say, of course, you should contact everybody. You should have recorded letters going out, and we can run the whole process for you. And you know, just send us your bank balance now. Or you can just say, come on, this is a waste of time. None of our customers will care. They expect us to keep VAT records because, hey, everybody knows what a VAT record is. And you might then just simply publish on your website or some other obvious place what your approach to retention of different types of data is, so that it's publicly available. It says, we keep this type of data for this type of period for this type of purpose. But then rigidly stick to it, so that when the period, the 6-year rule, which is typically what applies to corporate records, passes, destroy the data. Does anybody have boxes of data in a storage facility somewhere? Yeah, you should probably burn it all.
I did, I've just been through a bit of that actually.
Okay, because you probably don't have a lawful basis for processing it. It's probably all old.
It's not file either, properly.
Well, it'll be a structured file. I've got a box here and it says month 1 to month 6. A bit of a jumble, but that's going to be a structured filing system. I'm going to suggest that.
What about digital backups?
What do you reckon?
That's definitely structured.
Yeah, definitely got personal data on it.
I
So if I say I want to know what data of mine you're processing, you've got to tell me what's in your backups. And there's existing case law which says exactly that.
But what if retrieving that data puts their data more at risk?
Really? You've got a bigger problem.
yeah.
Now, retrieving their data puts their data at risk because they've got a right to security in the processing of their data.
I do want to ask you,
But if it's in encrypted sort of snapshots.
Fine, encrypted is good, but I'm still entitled to see the data.
well, this is a question that I probably don't want to drag you down this unless you've got a real simple answer to it. I'm a user, just a punter, and I'll say, you know what?
What we call a data subject.
Yep. Going to use that as well. I want you to remove my data as if I've never been there.
Yep.
Do they then have to go through every single backup and remove me out of the backup as well?
Legally, yes.
They would.
They might not, but legally, yes.
As if I've never, because it's as if I've never been there kind of.
Well,
talk about,
it's,
isn't it?
it's the right to be forgotten has a number of limitations. There is a, as far as reasonably practical component to it.
Yeah, because you can't have like a one-way email conversation. You can't delete all my emails because I'm there with the other party's emails as well.
Sure, if I'm dealing with your issues, I can't destroy somebody else's data, so I've got to work out how to do that. There is a clause in GDPR which is the particularly frightening one. It says taking account of the state of the art.
Magic.
But seriously, taking account of the state of the art, how do you prove that you took account of the state of the art in making your decision about what data would be backed up and how? It's a specific requirement. It says taking account of the state of the art.
It's your reasonable knowledge.
You've got to have reasonable knowledge, you've got to be up to date, and what I think it means is that in 5 years' time, when technology is caught up with regulation, you won't be able to say, but we're still on the 2017 release of this backup software, and we can't possibly get at the data that the data subject wants. Because the law court's going to say, state of the art, you should be on version 2022, which enables you to very easily identify and delete the data.
Just think we use a company called Mimecast, so technically.
Mimecast has a huge problem. They have this big claim,
Forever.
they have a big claim that they keep data forever.
Yeah.
You probably want to stop using Mimecast.
Well, what we've
And I say that because Mimecast is a processor,
I don't know.
you're the controller,
Yeah, we can
so,
control them.
correct, so they have to comply with your requirements.
But we can set it in our portal. Currently, we keep emails for 10 years. We would just shrink that down.
Fine, as long as you can shrink
we
it,
can
and as
search
long
the
as you do,
system and delete. So if you said you want all your emails deleted,
Perfect.
we can go in as IT and delete them.
perfect,
As long as
exactly
it's
where you need to be. Right, so for consent to be informed, okay, consent has to be informed, definition of consent. The data subject should be aware at least of the identity of the controller and the purposes of processing for which the data is going to be intended. It should not be regarded as freely given if the data subject has no genuine or free choice or is unable to refuse or withdraw consent. So if you're going with consent and you say, here are 8 things I want to do with your data, please consent, you know, and you know perfectly well the data subject looks at that and says, I'm happy with 5 of them, but I'm really not happy with 3 of them, you can't legitimately ask them to consent to all 8. Because it's not possible for them to have a genuine or free choice around the 3 that they don't like. So consent has to be granular.
Tick boxes.
Yeah, consent to this, consent to this, consent to this, consent to this. Different lawful basis of processing potentially for each of them, different retention period for each of them. You should already be looking at all websites, all systems, because the changes necessary to deal with this are not easy to put in place in a couple of weeks. separate consent to be given to different personal data processing operations. You can rely on consent, and as I say, consent's a really tough thing. I'm talking about it a bit so that you start saying to yourself, actually, let's not rely on consent. You have to be able to demonstrate the data subject consented to process. You have to be able to demonstrate, you have to be able to withdraw consent. Consent will not be valid where the controller's contract performance is conditional on the data subject's consent. I won't let you have this download of this green paper unless you give me your details.
See that a lot. See that a lot.
Of course, yes. That's all people doing what kind of works for them as an organisation. And all GDPR is doing is saying, actually, data subjects own their data. They should be in a position to make free choices.
To get access to like a lot of white papers, you have to put the details in so they gather your data.
Sure. So don't rely on consent. So I have a legitimate interest in collecting your data in order to give you this because I want to send you some more information if you don't like that. But don't rely on consent. That's why I say you've got to really think about what's the lawful basis of processing. Don't just default to the consent. Everybody goes for consent. Think about the implications of consent and what alternatives there are. Make sure you're dealing with a lawyer who's practical and intelligent, not a lawyer who says, no, everything's impossible. To rely on consent, as I said, have to cover the processing activities for the purpose. If there are multiple purposes, purpose of consent should be given for each of them. Specific rules apply to children. GDPR says that, in general, people under the age of 16 may not consent to the processing of their personal data for information society services. That doesn't mean for everything. It means very specifically for things like social media, online accounts, apps, all of that kind of stuff. If you're 16 years or under, you can't consent unless the member state of which you're a resident has a different age of consent. The minimum is 13. UK's gone for 13. So in the current current data protection bill, it's selected that derogation of 13. That means if you're providing services that are likely to be attractive to minors, you will need to have in place a mechanism for ensuring that you know the age of the person who's consenting. Not only will you need to do that, you'll need to have a mechanism for being sure that the person who gives consent on their behalf isn't another 14-year-old, but is actually the adult who has authority to consent to that processing. So for all of those of you who have young children who prefer to spend their time on Facebook rather than doing their homework, that's how you stop them. You say to Facebook, you may not process their data because they're under the age of 13. I haven't consented. Facebook then has to stop.
From my next account.
If they don't, which they probably won't, or for a while anyway, until the European Commission comes up with a couple £100 million fine, they'll have to stop. And when your child gets their best friend to pretend to be their parents, Facebook is supposed to have a mechanism for ensuring there isn't. It might be a camera, might be some other form of identification, but it's a very specific requirement. So withdrawing consent, if you rely on consent, the data subject has to be able to withdraw it. There's a whole bunch of problems and complications that follow on from that, as we were saying earlier. You can't rely on silence, inactivity, pre-tick boxes. You have to have a mechanism in place to tell people how to withdraw consent. If you're relying on consent, it has to be clear and explicit. We've talked about additional consent if the purpose for which you're processing the data changes. And you should, if possible, make it easy for people to control themselves what they're doing. So the ideal is a section on your website which enables data subjects to log on, update their data, manage everything that's going on. So that's the summary, particularly around social networking and processing of children's data. As I said, it does not affect any other legal right of consent that minors might have. You will read sometimes people saying this applies to children's consent to anything. It doesn't. It's very specifically limited to information society or information age services, online services, apps, social media, those kinds of things. If a child's got a right to give consent to medical treatment under an existing law, they have that right. This doesn't affect any other rights. It's only about consent to their processing in respect of information society services. So we talked about Article 6. Article 6 sets out the conditions that you can rely on for lawful basis of processing. If you want to process what's called a special category of data, That starts with race, ethnic origin, political opinions, philosophical belief, genetic data, biometric data, health data. I want a doctor's report on your asthma, whatever it is, sexual orientation. All of that is a special category of data. GDPR says it's prohibited to process that information. It's the starting point. It's prohibited. It's not legal to process that information unless you can rely on one of the exemptions in Article 9. So this is Article 9 of GDPR, and the exemptions from the prohibition. And it's important to understand it's not you also have to be able to identify. It's a prohibition from doing something unless you can identify how you are exempt from the prohibition. The data subject is given explicit consent. And this is where you need to think about explicit as being more than just yes, okay then. Explicit means understanding exactly what the information is going to be used for, exactly who's going to see it, how long you're going to keep it, how it's secured, anything that might enable them to make a proper judgment as well whether they want you to have that data. Or it's necessary to fulfill obligations of the controller or the data subject in employment or social security. So you might need to process health information in relation to someone's employment. That would be the basis on which the exemption that you would rely on in order to process that data. So remember in Article 6, lawful basis, in order to fulfill a contract, and then Article 9 exemption in order for us to fulfill obligations as an employer, we need to make sure that you've got proper access if you are physically disabled. So we need to know whether or not you are. So in explicit purposes, you can do that. Vital interests, it's legitimately carried out by a foundation or not-for-profit organisation which gets some charities out from underneath that hook. It's been made public by the data subject, manifestly made public by the data subject. Somebody outs themselves as having a particular sexual orientation, you can process that data if it's been manifestly made public. But you can't use it for purposes that you want to use it for without having told the data subject what you're going to do. And then the others which are, in most instances, unlikely to apply to organisations other than in the public sector. Processing of data relating to criminal convictions is also prohibited. It can only be carried out under the control of the official authority or when authorised by the government. You can't keep a register of criminal convictions other than with the authority of the government. And that's dealing with abuses which have happened over the course of the last years where particular sectors have had lists of peoples which they think might have or could have criminal convictions, and they share them amongst one another and people don't get jobs as a result. You can't legally process any of those kinds of databases without formal permission. So that's lawful.
That go with driving offences with insurance companies. Do they allowed to share that data around?
So it's a legitimate basis. Fairly, so principle one is lawful, fair and transparent. Those are three tests. We've only just talked about lawful. Yes, so complying with GDPR is not as easy as just these 6 principles. Wow, that's straightforward. Lawful has to be fair. Fair means that you basically have to identify who you are. The data subject has to get information about how you're processing the information. No deception as to what you're doing with any information that the data subject might need to know that the processing is fair, which includes what other third parties might I be sharing the data with. All of that has to be provided in what's called a privacy notice. At the moment, those appear in the form of fair processing notices or privacy policies. In the new world, all of that simply becomes a privacy notice. And there are 2 types of privacy notice. There's what's called an Article 13 privacy notice, because it's described in Article 13 of GDPR, and an Article 14, because it's described in Article 14. Article 13 privacy notice is the kind of privacy notice you give to a data subject when you've gathered the data from the data subject. Article 14 is when the data's come from someone other than the data subject. So you can still buy lists under GDPR, you can still collect data from social media. All of those things are possible, but before you do anything with data that's come from third parties, you have to tell the data subject. So collected directly from the data, you basically have to say who you are, where you've got, what data you've got, what you're going to do with it, what the lawful basis is, what your legitimate interests are, if you're going to transfer it to a third country or third party. You have to tell everything that you plan to do with the data. So if you think of it as, if the data subject comes and asks me what data I've got, they shouldn't be surprised. I should be able to say, yes, I told you, there's the Article 13 privacy notice. You got it, you saw it, it was made available at the point I collected your data.
Once you've acquired some of these data from a data provider, you still then need to contact the
So if you get the data from a third party, you have to give a privacy notice to the data subject direct. Yeah, and that's the Article 14 notice, which is everything as Article 13, plus where did I get the data from?
Can that sit in the employee handbook that you mentioned earlier, all about information?
So I would put all of that for employees in the employee handbook. So when I was talking about retention periods, lawful basis, I'd have all of that in detail, probably over a nice big chart.
Gender, your ethnicity.
Correct, exactly right. If we're collecting this, we know it's prohibited, but we're relying on this exemption for this particular processing, and we'd then be explicit about what we're doing.
We can build it all into one statement there.
Yeah. And I'm only saying that now because that's what we believe. In a year's time, there could have been 3 or 4 court cases saying, no, that's not transparent enough. But I can't see why, none of us can see why that's not a logical thing to do. We do it with health and safety, we do it with everything else.
So we have accounts open through an intermediary, and then the customers send a contract. Is it okay to have that detailed in the terms and conditions of the contract? Is that explicit enough?
So this kind of gets complex. You have an intermediary who refers a customer to you, and you then send a contract to the customer?
Financial advisors, so they apply for account on the customer's behalf with their information.
So are the financial advisors employed by you or independent?
Independent.
So I think probably, are you determining what data they have to gather, or is the financial advisor determining it? Yeah, so you're the controller.
Yeah.
So you have to determine then what the financial advisors do. You have to tell them what information they have to give the data subjects. You're the controller. You're responsible for every bit of the chain that leads to the data turning up on your system. So you've got to say to financial advisors, you collect this data, this is the privacy notice you give the data subjects. That has to set out that the data you're collecting is going onto our system, what we're going to do with it, has to tell them how to exercise all of their various rights. That's all got to go in a privacy notice that you require by contract the advisor to pass on to the data subject. The other thing you have to do is what's called facilitate the exercise of rights by data subjects. Facilitate basically means make it easy. So you can't say, we know you've got some rights, if you call us in the middle of the night and there's somebody there, we'll tell you what a couple of them are. Yeah, you have to make it completely transparent. You have to make it easy for them to exercise the rights. There are 8 rights: rectification, erasure, restriction of processing, objection, data portability, etc. You have to tell people what their rights are in the privacy notice, and you have to tell them how they can exercise them. Call this person, send an email here, or even better, give them an online portal that enables them to exercise their rights. As I said, when it's come not from the data subject, but in the form of an email list, or you scraped it off social media, or wherever you got it from, that's fine. But before you do anything with the data, you send them a privacy notice, which includes, this is where I got your data from. That's good practice right now anyway. If you're onboarding an email list from a third party, you would normally upload it, email everybody and say, we got your data from this provider, this is what we're planning to do, this is how you can object. That's currently good practice.
What if I said to you that you shouldn't actually have my email in the first place, like you contacted me?
We'd say absolutely fine. That's why we're telling you now, this is where we got the data from, can you talk to them? Because if they sell us the list, they'll be selling it to a few other people, and we won't process your data.
Who gets the data runs of it? Like, call to say, okay, I had to get my data, and I call this other third party, and they said to me, okay.
So you would, if I've bought a list from a list supplier, I write to you and say, here's an Article 14 privacy notice. You respond and say, don't process my data. Where did you get it from? I'll say, I told you where I got it from. It's in the privacy notice. Right? That's exactly where it came from, their contact details, everything. You then get in touch with them, because I've complied with my legal obligations. Yeah. I've told you where it came from, and I've stopped processing when you objected. And I wouldn't have asked your consent. I would have said, I got your data from this list broker. I've got a legitimate interest in emailing you because from what I understand from the list broker, you have an interest in the things I'm emailing you about. You can object. This is how you object. I will respond to the objection. I'm in the clear. You're then going to get hold of the list broker and say, you never told me where the data came from. Stop. And if they don't, you'll then take them to court. You'll report them to the Information Commissioner and generally make their life a misery. Because you're entitled to. You're entitled to bring complaints, you're entitled to bring actions, all of that.
Who's responsible? Is it the company or the directors of the company?
A data controller is an entity, not individuals. So GDPR focuses on on entities. If the entity is a partnership, it will be the individuals who make up the partnership. If the entity is an individual who is trading as a business but is not incorporated, it will be the individual.
I'm just thinking a company could start up every 3 months to keep changing company name to try and get out of actually abiding by any of these rules.
Yeah, but there's a whole series of other complications which follow on from that, including the fact that under legislation which isn't being repealed, the directors are likely to get fined for carrying out fraud, particularly in relation to personal data. So, yeah, you're going to get crooks whatever happens, and GDPR doesn't remove the reality that crooks will subsist. It just means that for most people, life works better. So you have to tell data subjects where it came from, and then the third is the requirement for transparency. So lawful, fair, and transparent. Transparent means your data subject needs to be in plain language. If we're dealing with a Spanish audience, don't write a privacy notice in English. Data subjects need to be able to understand the privacy notice. They need to be able to understand what you're telling them about data. You need to be transparent about everything that you're planning to do. You shouldn't be doing anything that will have unexpected adverse effects on the data subject. You're going to do things that they would reasonably expect you to do, is what transparent means. And that finally brings us to legitimate interests. And legitimate interests is, on the one hand, a really interesting option. It's a lawful basis for processing data. It's a requirement of the second principle that you have a legitimate purpose. So you need to understand how to arrive at what is a legitimate interest, because, again, it's not clearly defined. What GDPR says is, in order to determine whether you have a legitimate interest or not, you need to carefully consider all of the impacts on the data subject. So I guess that means your little process, which says, yeah, we considered and we arrived at the decision because we complied with the law. Processing of personal data for the purpose of preventing fraud is a legitimate purpose. Processing of personal data in order to track cyber criminal activity on the network is a legitimate purpose. So you can simply say to people as employees, and we have a legitimate reason for tracking your behavior on our network because we want to prevent fraud and because we want to deal with the possibility of cyber crime. You can object to the processing as a data subject, and if you object as the controller, I can tell you the consequences are that your access will be refused. You're perfectly entitled as a data controller to tell data subjects there is a consequence to them objecting to certain types of processing.
So you don't have to remove data if people object, if you have a legitimate reason, right?
You have to consider the objection, and unless
answer.
you've got an overriding statutory or other purpose, which might include, I need it for a court case, whatever. You've got an overriding purpose, then you say, I've considered and no.
You just have to respond in a timely manner.
Respond in a timely manner. You have to go through it in a proper and a normal process. You can't wake up and say, sod you, you're the 93rd person who's tried today and I'm really not interested. You've got to go through a process, because you have to assume with all of this, if somebody's exercising a right, you have to assume it's the starting point for a possible law case.
And this is that whole point I think you said up front, organisations are going to literally have to have a named data controller, person responsible for this sort of thing. It's going to spawn a team of people. And
yeah, you don't necessarily need to publish the name, but in most organisations you should say this is how to exercise your rights. Email this email address, or telephone this number, whatever. This is how you're going to exercise your rights. So it's transparent. And when we're saying to organisations who've got a lot to do, we're saying to them, concentrate on two things. Making sure that you can deal with data subject access requests and that you can work back from there to sort out lawful basis and all of that kind of stuff. And make sure you're protecting your data. Put in place proper information security, penetration testing, all of those kind of things, because that cuts down the likelihood of you either having an upset customer or having a breach. And that gives you time to do what's going to take the next 2 to 3 years to do, which is embed data protection in the organisation.
one of you had that direct marketing. That seems an interesting one.
Absolutely, it's a legitimate purpose. Like I keep saying, GDPR is not trying to stop business. It's just saying you need to tell data subjects what's going on, and they own their data. So it's a perfectly legitimate interest to market people about products and services. How else will they find things? It's not legitimate to send people information they don't want to get. Yeah, which is, you take the simple example of, I asked you about fridges, now you're sending me information about holidays in Ukraine. You've got no legitimate basis for sending me information about holidays in Ukraine. I never said I was interested in them. I never go on holiday. I can't fly. I have a fear of heights, whatever it is. I'm interested in fridges. So you've got
Is this-
legitimate interest in sending information about fridges, about fridge support packages, about updates to fridges, but almost certainly not about ovens.
But I guess then that this is going to spawn just another people getting around this crack, isn't it? Because what if that, I'm sending you information about holidays in Ukraine, and by the way, there's a conference on fridges over there.
Because somebody's going to say, you're taking the P, mate, and is going to bring an action.
Yeah.
And remember, the fines go up to 20 million
So
euros.
it's a big risk.
Yeah, it's a big risk.
Try it on if you will.
And remember, if the individual wins the action for non-material damages, there's no ceiling on the award that can be
So
made.
it's 20 million government fine plus.
Up to 20 million.
Yep.
Okay, not
Yeah,
necessarily
up to-
20,
yeah,
up to, plus whatever gets awarded to individuals. Plus, even if none of that happens, all of the time you then spend fighting the action.
Yeah, that's the big cost, isn't it?
Okay, so it's much simpler just to go, let's just do this properly.
What do we do to legitimise processing to third countries? Is there anything we have to specifically say?
Lot of stuff. You've certainly got to tell the data subject that it's being processed and by whom, and you've got to put in place a whole set of legal protections. There's some tests that you have to do. We sadly haven't got transport data processing on the agenda for today. It's probably a good 35 or 40 minutes worth of exploration, but there's a specific set of activities that you need to do, bearing in mind that breaches of those requirements are the upper tier of fines. Bearing in mind that in March 2019, the wonderful Brexit is going to mean that all of the data processing between the UK and Europe becomes a problem, because the UK will be outside Europe. That's kind of apparently the point, which means that it'll be in exactly the same place where data processing is concerned as Cambodia. There will be no automatic basis in which you can assume that a UK company can process the data of EU residents. So as a UK company, if you're providing services into the European Union after March 2019, you're going to need to appoint a representative inside the EU.
Is that strictly true? I thought they're going to, well maybe I got this wrong, but all of European law to start with will be enshrined to UK law, and at that point they'll unpick the stuff they don't want.
That's exactly what's happening, but
Yeah.
just think about that for a minute. The European law says if you're providing services into the European Union, by definition, therefore, you're outside the European Union. The UK is outside the European Union. So, by definition,
Yeah.
we're outside.
Mm-hmm.
So, by definition, when we try and comply with the UK version of what then GDPR becomes, we have to appoint a
Because
representative
they'll
inside
start
the
to
European
move, we'll start to get drift, won't it?
Correct.
And we won't be a trusted country.
And we might not be a trusted country. What the European Union has to do somehow between now and March 2019 is come to the conclusion that the UK will have an adequate data protection regime, which America doesn't, so you can't transport data to America. Australia doesn't. And somehow we're all hoping like mad that in the same time period that we can't work out what the divorce bill will be and how to deal with borders in Ireland, the European Commission and the UK government's going to arrive at a conclusion that there is a genuine adequacy finding in relation to data processing in the UK. From a planning point of view, that's a dangerous assumption. So, legitimate interests, if you have a legitimate interest, you need to be clear about what it is, you need to document it, because the underlying requirement of any set of laws is that you need to make sure you can prove that you're doing what you're supposed to be doing. So, of course, as a company, we can give you access to really helpful books and pocket guides. You can read all about it. You can get a set of documents to help you comply. A gap assessment tool, which if you know what GDPR requires, helps you work out how big and multiple your gaps are. There's a bunch of training courses. You can get them obviously through us or through TIG. Foundation practitioner training courses that go through all of the stuff in some detail. And there's a whole bunch of consultancy services that, as you might expect, help you think practically and pragmatically about how do we go about staying out of jail. Not jail, out of trouble.
Slides.
Yeah, I was just going to ask. Is there a starting point, Doctor, of where do you start? Certainly as a starting point, I should review my employee contracts and review my end-client contracts as a starting point.
Starting point is to get the board to recognise this as a risk, to get it on the board agenda and get somebody on the board to say yes it is, make it a matter of board minutes and we're going to have a plan, because that's how you begin to demonstrate accountability.
All right, so we should, I mean, I'm on board, right?
Yep,
So
that's
I should,
cool.
I should just make some notes and minutes and distribute
Yep.
them and make sure I've got a
Yep.
presentable copy of them.
Yep, so you've got evidence that you recognise it as a risk, and then from there you do a data inventory. What data are we holding about personal personal data subjects. So customers, suppliers, employees.
Okay.
Having done that, you then say to yourself, how do we apply these 6 data processing principles in respect of each of those databases?
Okay.
Then you go, I think I'll change a lot of things I'm doing,
Or wrap it up.
or whatever it is. But bear in mind that GDPR is not trying to stop you doing stuff. It's trying to stop you doing stuff which data subjects don't expect you to
Well,
do.
the
So you
flip
might
side
have to
of the coin,
think
right?
about, how do I do this in a better way?
If you look at the flip side of the coin, as a data subject, we all get the ache about our stuff being
Correct.
abused. And I'm trying to keep my hat on with that and recognise that I don't want my personal data out in the wild either.
Correct.
So,
And
it's a
that,
balance.
that I think is one of the best tests for any organisation saying, should I do this or not, is to say, how would I feel if this organisation did that to me? And if the answer is I'd feel pretty rotten, then don't do it, because on balance it's likely to be illegal.
yeah.
Just want
Yeah.
to, we've got 10 minutes left, and they are quite strict on timing. I want to give everyone the opportunity to ask questions. So please ask your question, then we'll start from the back. There's a few people in the back wanted to ask some questions. So please ask your question first, and then.
Just a quick one. So, I think it's pretty obvious already, but a data subject is pretty much any person that you have information about. So it could be a business contact, an employee,
So the definition of data subject is a natural person.
any natural person that have any information.
So it's a live human being.
Not an entity.
Not an entity, that's a legal personality. Legal personalities have no rights, it's only natural persons. Not deceased persons, but
within an
natural persons.
entity that you do business with.
Sure, absolutely, because that's good. Identify something. It's a personal email address, it's an IP address, it's personal data.
So should we just start back to now? There's a few questions at the back. Has anyone got any questions? Back row? No? Right, so the lady there.
The advice we have from quite a practical lawyer is that we have multiple purposes for processing. So most of it's going to be housed in legitimate interest, contractual necessity, great. Direct marketing, electronic marketing, consent trumps everything. And you've still got the, you'll have the privacy directive at the moment, you've got PECA. So you're not going to get away from for marketing, you're going to have granular and specific. That's all.
You have to have granular and specific for everything.
For contacting your customers, and that's both for actual marketing, whether it's for us or for our partners, and even if you want to talk to them about you sell fridges and you want to talk about freezers, you still need an active consent. That's where we're going. That's why we are.
You don't need to. There are lots of lawyers. There are lots of lawyers I know who are going down a complete belt and braces perspective. Lawyers don't have to live in the real world. And much as I love lawyers, one has to bear in mind that they're simply telling you how they currently interpret the law. The practical reality of businesses is how do I comply with GDPR in a way that enables the business to work, my customers to be happy, and not to fall foul of the law. There is nothing in GDPR which says you have to get consent at a granular level for every bit of processing that you might do in terms of direct marketing. Direct marketing is a legitimate interest. Legitimate interest is a lawful basis for processing data.
You've still got the PECA now, and then the privacy directive.
EPR, if you read the current draft of EPR, does not undermine anything in GDPR. And the current draft of EPR is expected, or they're hoping will bring it into force on the same date as GDPR. PECA does because it was, at that point, a step on from the Data Protection Act in terms of trying to look at what it called soft opt-in effectively in a business environment. But that gets killed. From a GDPR and an EPR point of view, legitimate interest is a lawful basis for processing data. Direct marketing is identified in one of the recitals as a legitimate interest. So,
marketing by you and your partners, they're not you.
Now partners is where it kind of gets hard, because you have to be clear about how, I mean, in assuming that you've got a legitimate interest to direct market, you have to be clear about what the direct marketing is. You can't just say, because I've got your name, I'm going to send you information about a million things because I've got a legitimate interest in marketing, whatever I like. The legitimate interest has to be related to something or other that you've got from the customer, or that they're aware of, or that they know about. You have to go through how does this get to be a legitimate process? If you think there's an argument that says marketing by partners is legitimate, you've got to work through that. And I suspect that in 9 cases out of 10, you'll come to the conclusion there isn't a legitimate argument for the associate or partner marketing. There might be if you're a price comparison website. You might say that when you come on here and you put your name into these kind of things, each of the partners to whom you provide information has got a legitimate interest in responding to your request.
We might talk about it separately.
Yeah. As I said, there are a lot of lawyers who are just simply going down the consent is easy, it's the first step route, but actually consent is not easy in practical business terms. It's easy from a legal point to say, yeah, consent to everything, but the ramifications of relying on consent for everything are huge, not just in terms of the barriers it creates for customers, but in terms of the realities of processing afterwards.
I understand that, but
Yeah.
for the marketing functions that you may have.
Sure, and I genuinely don't think it's necessary. There's
Sounds
some where it is necessary, but it's not on a blanket basis.
It sounds like a consultancy session is required. So
No, this is a legal session. It's a proper legal session. I
so
mean,
we've got-
we can tell you practitioner stuff, but you need to get lawyers and say, no, give me a different lawyer.
We've got time for 2 more questions. There's one here and one over there, because you both can put your hands up for a while. So do you want to go first, and then we'll ask you?
Thank you. For a global organisation, obviously there may be a requirement to share information to parent company within the US, for example, outside of the EU. So presumably, as long as there's a legitimate interest for sharing that information, and the technologies and controls to protect that information are in place, and you provide information to the data subject about what and why and where and how is being given, you don't require consent. That's a question.
If you put aside consent, you require a lawful basis for processing the data.
Yes.
You might have a legitimate reason for processing in the US.
Okay.
The Article 6 requirement around security says you need to secure the data. The United States doesn't have an adequacy finding, so it's illegal to transport data to the United States anyway. So the only way you can do that is if the US parent company has a privacy shield registration,
Okay, yeah.
or you have binding corporate rules in place.
Okay.
And if you worry about the survival of the privacy shield, then you might put both in place.
Okay.
But those are the 2 ways in which you make sure the US privacy shield or binding corporate rules,
Okay.
neither of which is simple and easy.
Well, one left over, the gentleman over there. You didn't mind it was ladies first, did
No,
you?
that's
Yeah,
fine.
okay.
Can you talk a little bit about the applicability of this to companies under 250 employees? Where that applies?
It applies to organisations of every size. GDPR says very specifically entities. The only point at which organisations under 250 have a derogation is around the level of paperwork applied. And essentially what it says is that organisations that employ fewer than 250 people do not have to have the same level of documentation as evidence of their records of processing where there is no risk to the rights and freedoms of data subjects. So the pain is in that where there is no risk to the rights and freedoms of data subjects. And we struggle very hard to work out which types of organisations will genuinely be able to say there is no risk to the rights and freedoms of data subjects amongst our 250 employees, because we've got 249 people, we don't process their data. So I genuinely can't see how that derogation actually practically applies.
So,
As far as we can see, that's a SOP. We cannot work out how anybody can actually genuinely make that apply, other than by really twisting what no risk to rights and freedoms means.
right,
And then it's only a limitation in paperwork, not a
Maybe
limitation
take
in
offline.
requirements.
right, so
Thanks.
any more questions, we'll have to take them offline. Because we do get hassled, and we're back here on 13th of December. They might not let us back in if we overrun again, as we always do. So 13th of December is the 3rd in the series, and I'm sure we'll be running into the new year with these as well, because there's a lot of interest. So if you have heard anything that you think maybe your CFO, finance director, your CEO, because this isn't really, so we run a lot of technical sessions. This is we cover the technology component, but really this is about understanding what GDPR means for your organisation. I don't need to explain that to you, because Alan's done a superb job in making that clear. So, if you want other stakeholders within the organisation to attend, please let us know in advance. December is getting quite busy already. As you can see, we've got some free chairs, but people say they're going to come and they don't come. Thank you very much for attending. Can you make sure on the way out Sheena's got she's ticked you off on the list, because only the people who attended will get the email with the content, and we'll obviously the people who didn't attend will invite them back on the 13th, and they can get the content as well. So I think looking at the presentation in isolation doesn't really do it justice. You really need to hear the explanation behind it. So we don't believe in sort of sending blanket information out for the sake of it. There's got to be some substance to it. So again, thank you very much. If you've got any burning questions, what I ask you to do is maybe step into the lounge. I don't know if you've got 10 minutes. If that has got a few minutes here, you can run over. But we'll just sort of grab a seat in the lounge, or please contact one of the TRG people, and we can set a session up or put you in touch. And it depends. It might be a joint session. Do you want to talk about technology and how you tackle the processes, or it might be just something you want to engage directly with Alan and his team on. So just let us know if you want to engage. So we can probably take one or two questions in the lounge if that's okay. Not too many because it's a members' lounge and we're encroaching on their space. But again, thank you very much. Just make sure Sheena knows. Did everyone enjoy it? I didn't ask.
Yeah.
So a round of applause for Alan. Thank you very much.